Harshita, you can start.
Okay, ma'am. Good evening to all. I'm Harshita Agarwal. ADR Bar, in collaboration with Legalify India, is organizing a panel discussion on the mediation bill, navigating the role of mediation in legal landscape. This event is the chance to delve into the world of mediation in the legal landscape. Before proceeding further, I would like to introduce our keynote speakers. First, we have with us Mr. ESA Agenratham, Empaneled Mediator, Consumer Mediation Cell, NCDRC, and DMAT. Next, we have Mr. Shaurya Krishna, Advocate at Supreme Court of India. And finally, we have Ms. Mehak Rathi, Advocate at Delhi High Court, Certified Mediator, Torchbearer, Mediation, ADR Bar India. We welcome you all. Now, I invite Ms. Sanjana Sachdeva, an advocate at Supreme Court of India, member of ADR Bar India, and a member of Cyber Hub to take over the platform.
Hello, everyone. I welcome you all to the panel discussion on mediation bill, navigating the scope of mediation in the Indian legal landscape, organized by the ADR Bar in collaboration with Legalify India. Some general rules before we begin with the discussion. I will request all the participants to please drop in their questions in the chat box, and we will definitely take them up at the end of the session. I will also request the participants to please keep their mics on mute so that we can hear our experts without any disturbance. And now I will take the privilege to introduce you all to our esteemed panelists for today. It is my utmost honor to introduce you all to our first panelist, Mr. Agilantam, who is an impaneled mediator with the Consumer Mediation Cell of the National Consumer Dispute Redressal Commission, as well as the GMAC, that is the Gujarat Mediation and Arbitration Center. Sir has a rich experience in resolving disputes through the ADR mechanism, especially mediation, and I believe nothing better than hearing from him today and his thoughts as a mediator on the newly introduced bill. Thank you very much, sir, for joining us today. Next, we have Ms. Mehak Rathi. Ms. Mehak Rathi is currently practicing as an advocate in Delhi and is a certified mediator with Phoenix Dispute Solutions UK. She also handles various arbitrations as a counsel and a tribunal secretary. She is one of the founding members of the ADR Hawk, which is established with a vision to promote ADR as a means of dispute resolution. And she is also the head of mediation wing from North India for the ADR Bar. Mehak is actively involved in a variety of awareness, educational and mentorship initiatives, one of which is Knowledge Steel, wherein she serves as the honorary director. Mehak has also been honored by the Tamanna NGO among the top 121 females of the country for her contribution to women empowerment. Mehak also holds several publications in her name, and we are absolutely delighted to have her with us today. Thank you, Mehak, for joining us today.
Thank you so much, Sanjana.
Now we have Mr. Shaurya Krishna. Mr. Shaurya Krishna is an independent counsel having expertise in a variety of practice areas, including the criminal law, civil, corporate, real estate, service matters, consumer, and more, before the Honorable Supreme Court of India, high courts including the Delhi, Allahabad, and Lucknow, other district courts and tribunals of the Delhi region. Shaurya also serves as a panel advocate for the Lucknow Development Authority, representing before the Supreme Court of India and the Department of Commercial Sales Tax, Uttar Pradesh, before the NCLT and the NCLAT. Shaurya is an advocate for various social issues and speaks very frequently on various cases such as child rights, economic empowerment, disaster and humanitarian relief, and other human rights, etc. Thank you very much, Shaurya, for joining us today. We are delighted to have you.
Thank you, Sanjana. Thank you for the warm welcome.
Now, I would take this opportunity to introduce you all briefly to the topic of today's discussion, that is the Mediation Bill 2023, and its predecessor, that is the Mediation Bill 2021, which was tabled in the Rajya Sabha in 20th December 2021, after which the Standing Committee issued its 117th report on the Mediation Bill and made certain recommendations to the provisions, post which the Union Cabinet approved some of the recommendation and therefore introduced this current Mediation Bill 2023, which was passed by the Rajya Sabha on the 2nd of August and then the Lok Sabha on the 7th of August 2023. Now, while the bill awaits presidential assent and is yet to become an act, it has already been in the talks for a while now. And with this panel discussion, we will primarily cover three aspects. Number one being the salient features, number two being the objectives of the bill, and lastly, the pitfalls, challenges, or the nuances of this bill. To begin with, I would request all the panelists to just briefly introduce the bill and also share their thoughts on how this bill actually promotes a non-adversarial mindset by encouraging mediation as an effective means of dispute resolution. I'll also request the panelists to just draw a comparison between this current predecessor mediation bill 2021. Mehek, if you may please share your thoughts on the same.
Okay, I thought I was the third one to speak, but anyways, yeah. So we're talking about mediation bill today. I think yesterday it was passed and enacted. Now there was a buzz when I was in my law school about arbitration, making India a hub of arbitration, and of course, arbitration is still growing. But at this point of time, all the law students who've joined us would have seen on LinkedIn, okay, there's a buzzword, another buzzword, mediation. So now you've joined a panel discussion to hear what mediation is, or maybe to get a certificate on, a mediation. So why is the need of this mediation act, and what happened with arbitration? That of course all of us know arbitration is still growing, but mediation per se provided a more cost effective and a time effective means of dispute resolution. There are doubts about effectiveness of mediation as a means of dispute resolution in India per se. But yes, when we talk about the process of mediation and resolution of conflicts through mediation, I am a pro-mediation person, but yes, effectiveness is yet to take place. The new bill has been introduced, of course, with a focus to promote and facilitate mediation, specifically institutional mediation. Prior to this, every high court had their mediation center attached, their rules. So a uniform effort has been taken. India, of course, was a signatory to the Singapore Convention. Now, there's one thing which I would like to highlight here. The 2021, Sanjana, you said if you could do a comparative analysis of the 2021 bill and the current one. The 2021 bill said that civil and commercial matters shall be referred to mediation before they're filed in court. Now, after rectifying it, the word is civil matters may be referred to mediation before filing, and commercial matters, of course, continue being governed by the Commercial Courts Act. This, of course, was challenged a lot because voluntariness is one of the main pillars of mediation, and making mediation mandatory, a lot of people challenge that is against the very voluntary nature of mediation in itself. And secondly, in a country like India, not everybody, access to justice in itself is questioned quite a lot of times. So how can we expect mediation to flourish and make it mandatory? So that is why I'm very happy that it has again been made voluntary. At a practical level, of course, there was another question about enforceability of mediation. If we check, I cannot recall the exact number, but India ranks around above 70 when we talk about ease of enforcement, or being enforcement of contracts or something, ease of doing business. Why? Because there's a lot of issues. When arbitration was introduced, there's a provision that arbitration will get over in 12 months, but then either you or me or any party will challenge it in court, and the same process is repeated. So that is another challenge which was there with arbitration. And I'm very hopeful that this new bill will address those questions to some extent, and that is why also Singapore Convention was brought into effect. That is what is from my end. And when we were talking about enforceability, of course, now mediation settlements will be enforceable a little better. So I'm very hopeful as to see how it goes.
Thank you very much, Mehak, for sharing your initial thoughts on the bill. Sure, if you may please build on the same.
Yeah, good evening to everybody. The entire India is celebrating Gokulashtami, and Lord Krishna is the first mediator in the world between Kauravas and Pandavas. With this, I start the mediation bill way back started from 2005. It emerges from the 2005 and slowly it is tabled on Rajya Sabha in December 2021, and now it takes a shape by passing the bill on 2023. But before we go to the mediation bill, why mediation is going to be the top of the agenda as well as the top of the Singapore Convention, because we should know the current situation of this scenario in India, especially on the legal framework. You know that every day 40,000 cases are filed and the pending cases is 3.6 crore. And litigation, most of the people never come to the for an alternative is 67%. The people doesn't know about the alternative solutions, and the cases are piling up every day. And moreover, as Mahi has pointed out, that easy way of doing business, 80,000 crores business is lost in India, and it takes to finish a case more than 13 years. You see the scenario, the current situation in India. And moreover, mediation is basically now comes under a professional setup. It comes out of legal framework, and more professionals can enter and do a better service, a better way of dealing the disputes and come to an amicable settlement of both disputes and other solutions to both the parties. So we can expect more transparency, as well as the time duration. As far as arbitration, the law says about 12 months, but even in mediation, it takes days or weeks or a month, it can be finalized. So the government has taken a right step in passing the bill in 2023. Though the Singapore Convention of International Mediation is not enforceable, we should appreciate that the mediation 2023 is going to play a major role and solving most of the cases in amicable way. That's what I feel, and I want to share this. Thank you.
Thank you very much, sir, for sharing your insights on the same and for also highlighting the various objectives of the bill, that too very briefly. Thank you, sir. Shaurya, if you may please continue and share your valuable insights.
Thank you, Sanjana, for the warm welcome, first of all. My greetings to the co-panelists and moderator and the audiences. We are now in 2023 and we have seen the influx of Mediation Act 2023 now. And since mediation is more about willingness, we are going towards the era of mutual settlements at a pre-litigation stage by eradicating the traditional system of law, the traditional system of maybe the judiciary in future. I was listening to the Honorable CGI in one of the lectures, and he was talking about the mobile courts. So the courts should be accessible to the people, to the masses where they are. Courts belong to the masses. The masses do not belong to the courts. But since we are coming to the topic wherein the masses do not even have to come to the court, this Mediation Act talks about, highlights upon such terms like pre-litigation mediation, mediated settlement agreements, the terms which we used to see in our moot courts of international moot courts sometimes in the UN conventions and the international spheres as well. And since India has decided to become the hub of arbitration, the ADR in fact, this mediation bill is going to play a very vital role in the coming years. And as Agilantam sir has very well reminded me that the first propounder of mediation was Lord Krishna, and I then got reminded by a very famous poem, a kavita by Dinkar Sahab, which was Krishna ki Chetavani. And it started like वर्षों तक वन में घूम घूम, बाधा विघ्नों को चूम चूम, सह धूप धाम पानी पत्थर, पांडव आए कुछ और निखर, सौभाग्य न सब दिन सोता है, देखें आगे क्या होता है. So all the very best to my co-panelists and the audience. I hope we will deliver a very good lecture. Over to you, Sanjana. Thank you.
Thank you. Thank you very much for your valuable insights on this same, Shaurya. Now, as you rightly talked about the voluntary pre-litigation, which is now a very talked about aspect of this new mediation bill. The new mediation bill very swiftly makes a change from mediation being voluntarily and not a mandatory process for commencing litigation. So, do you think this is a positive move, given that mandatory pre-litigation mediation was seen to have the potential to speed up the resolution process on one end, and on the other hand, it was also encouraged the denial of justice and the very important aspect of party autonomy or mutual consent? Ajilantam sir, if you may please share your insights on this.
See, basically, mediation is a supportive process for the lawyers as well as the clients. You should take it in that sense only. And it reduces the burden of both the parties and the stress. Because once the lawyer takes a role as a supportive role of a mediation, or a professional takes a supportive role of a mediation, they can be rewarded on all sides. It's a win-win situation for all, as far as mediation is concerned. So there is no question that the litigation part cannot be resolved. The litigation part can be solved if the lawyer or the professional mediator plays a supportive role to the respective clients and bring an amicable solution and a settlement, and with a short span of time. That's what I feel.
Another follow-up question in that similar line, sir. Although the bill has encouraged mediation as a consent-driven and voluntary process, I believe that this is not what the bill actually aims for when it comes to a true sense. Do you think this could potentially increase the burden of the court and can eventually lead the parties back to litigation?
No, because the success ratio of mediation is more than 50%, which no other, even arbitration cannot do that. That is one point which we should remember. The success rate of mediation is more than 50% as per the latest report. And secondly, it's better than the arbitral award. It is mediation, once finalized and agreement is signed, it is like a judgment of a court. So that is one advantage on this mediation bill. And the more thing is that the accreditation and quality of the mediators is very important. That's what the bill has to specifically pointed out, that more professionals will come and more services can be drawn from the professionals, so that the mediation can be sped up in a better way. That's what I feel, and it will not be a burden to the court of filing of cases, which I feel personally.
Absolutely. I absolutely second that thought, sir. Now, moving on to the very important aspect, like I said, is the party autonomy and the mutual consent. Let's consider a situation that on a failure of agreement between the parties, an appointment of mediator by the mediation service provider results in conflicting circumstances, which raises doubts on its impartiality. Given that the bill doesn't specify any grounds or boundaries relating to the circumstances that could lead to impartiality, how do you think, sir, this could be handled in such a scenario?
No, it cannot be a partial one, because you are going to involve a third person, which both the parties might not be aware of the third person, and the person cannot be favorable to one or another. As Lord Krishna has been very clearly telling the point both to Pandavas and Kauravas, a mediator should play a role of more than a judge, and should deliver which is right for the mediation, and what is right for this party or that party. So I don't think that it depends purely on the person or the professional person who takes mediation as a professional way of taking the mediation to the next level. It purely depends upon the individual who takes the mediation.
Absolutely. Thank you very much for sharing your thoughts on that, sir. Another significant feature under this bill is the registration of a mediated settlement agreement, which is optional as per this bill. Moreover, the bill does not specify the implications of an unregistered mediated settlement agreement, which is very surprising. What do you think, surely, could be the fate of this provision, considering that the law on this is pretty much clear when it comes to arbitration?
Well, Sanjana, none of the acts specify that what happens to the agreements or the documents they have which are unregistered. But it's a very pertinent question to ask. You know, as lawyers, it is our habit as well as duty to verify or cross-check every piece of paper that we come across, even in the form of documents. Similarly, the courts of law also verify these documents, agreements, and subsequently the contracts. Now, since we have an understanding about the settled law in the field of arbitration, it's a very recent pronouncement by the Honorable Supreme Court in the Messrs. NM Global Mercantile Private Limited versus Indo-Unique Flame Limited and others. The Honorable Court has clearly bifurcated between the status of arbitration agreement in the Arbitration Act and the Registration Act, where the agreements are registered. Now, the Honorable Court recognized the independent nature of the arbitration agreement, which may or may not be registered. But if it is a part of such a contract whose registration is compulsory, where the payment of stamp duty is compulsory, then its fate depends upon that particular contract, the fate of the arbitration agreement. Now, coming to the mediated settlement agreements, now MSA is entirely an independent agreement. Now, Registration Act talks about registration of the documents, registration of the agreements, which involve certain kind of commercial transactions, which has a commercial trail. I'm just talking about the legal perspective. Now, MSA does not form a single chain in any transaction as of now. We do not know what holds in the future. Its nature is also not commercial at all. You know, we pay a certain amount of money during the registration of a document. I'll just give an example. We pay a certain amount of money during registration of a contract / agreement in the form of stamp duty. Now, what this duty is? This duty is a tax. It's a form of tax that we pay. And we pay taxes over our income, over our earnings, over something commercial transactions that we do, even if it is in the form of property or any immovable property or any transactional or operational commercial contracts. Now, this MSA in its very nature does not lead you to any commercial venture. It is a very willful understanding between the parties. Therefore, its fate, the fate you were talking about, its fate, though is slightly vague, but it should not be held up in legal complexities like that. Since it's not commercial in nature, I believe that as of now, let it be in the gray area. Let the courts adjudicate the matters first. Let us debate in the courts first. Let us be the bigger minds, the more illuminated minds work upon this aspect. And you are absolutely right. The bill is silent about it. We do not know what holds in future.
Absolutely, absolutely. Now, speaking about the mediated settlement agreement, another important aspect that is attached to it is enforceability of the same. The proposed law would make it possible to enforce an agreement much like a court decision or a regular court decision. How far do you think this could impact the finality of the disputes between the parties?
Well, I believe this making the mediated settlement agreement as just like a decree or an award of the court. I believe this is the most crucial and much awaited part of the mediation bill, the Mediation Act now. We believe that the court's decree is a word or a mandate given by a god, and it's the final wordings. But by the inclusion of this section of enforceability, the lawmakers not only strengthened this particular act, but also made sure that none of the parties use mediation as a tool to prolong any kind of obligations that they were supposed to complete. They do not try to further harm or violate the rights of any of the other parties. So this enforceability part of it is very crucial, and it added some sort of seriousness to the pre-litigation stage. Otherwise, what used to happen, like as of now, we used to file one civil suit before the commercial court, it goes to the mediation cell. Many of the cases are being filed just to prolong the litigation, just to prolong the payments, so that the mediation is going on, and they have this very kind excuse that a mediation is going on, so how can we repay you the amount? And since there is no finality or enforceability of that particular mediation that is going on, this kind of acts, the misacts, the misbehaviors, or the mismanagement of the particular provisions that we have used to take place a lot. But by the incursion of such sections, such enforceability clause, I believe that it will curb a lot of problems. It added some sort of seriousness, yes. And well, of course, if there are lawyers, there has to be litigation, even after the success of the pre-litigation. And it cannot be said in the wider perspective that the finality attained through mediation is just and proper. You cannot say that. It cannot be said that since the issue is resolved at a pre-litigation stage, the issue is resolved at a mediation, it is said to be fair, wise, and justifiable in nature. Now, we have to keep in mind that to err is human, and mediation settlement agreement could malfunction, and observing its naive stage, we cannot say that it should attain the finality very soon. And with respect to the word finality, it is often said that, since I'm a practicing advocate at the Supreme Court, I often say that Supreme Court is not final because it is right. Supreme Court is right because it is final. So pre-litigation stage, it's the first step of stepping stone into the litigation. So we should not call it a final verdict of God.
Thank you very much. Absolutely. Thank you for adding a touch of your practical experience to that answer. That was very, very impressive. Thank you very much. So coming now to the next aspect, another important aspect is whenever there is a negotiation or a mediation between the parties, or let's say any court matter, confidentiality is a very important aspect. So surprisingly, this bill does not provide for penalty for breach of confidentiality. So do you think, Mehak, this is a flawed provision and this may not be effectively followed by the parties?
Sanjana, I lost you at the end, but I get your question. So confidentiality again is one of the another crucial pillars of mediation. Whenever I remember when I was being trained and we were conducting trainings, everybody had to say, okay, confidentiality, confidentiality, confidentiality. There were so many sessions on confidentiality. Agilantam sir is laughing because he's one of the first batches who was trained with ADR Rock and ADR Bar. So yes, confidentiality is of course one of the crucial pillars of mediation. When we say, you said there's provision, there's a specific section 22 talking exclusively about confidentiality, and you find mention of confidentiality everywhere, but you're saying that breach of confidentiality is not made punishable. Why? Because even if, let's say, we are conducting an online mediation or an offline mediation and you record something, confidentiality has been breached, do you think any court will admit that as a admissible evidence, or will that be admitted? I state that because when I initially joined litigation, I used to go and shout in front of judge, this party did not come to mediation for these and said these things, and judge would like look at me and don't do anything about it. And I was like, why is he not paying attention to the whole thing? Because he is aware that whatever happens in mediation is a confidential process and nothing can be used before court of law. So of course, it's very right that breach of confidentiality is does not find mention, but as already stated also, that there are certain things which are left in gray, and we are aware confidentiality has been emphasized upon. Every court is aware that it will not be relied upon. So I don't feel any need of it also.
Thank you very much for clarifying that out, Mehak. Now let's consider a situation that the parties sign a confidentiality agreement before they start the mediation process. Do you think or that this would lead to rise in more conflicts rather than decreasing the conflict?
See, the whole problem when we talk of mediation as a means of dispute resolution is we mostly take it as a measure to just buy some more time in court. We never take it seriously. But of course, when we were dealing with, when we were doing our trainings, and if there are very senior mediators, they would know that when there's a issue at hand, they are trained to go into the positions of the parties, the interests of the parties, to make them see so much. So any party will not be comfortable disclosing confidential information until and unless they are aware that it will never be used against them in any court of law. So of course, to settle the dispute for once and all, that is what is a beauty of mediation, that I feel. If as Agilantam sir said, there is a need of trained mediators. And in India, of course, there are a lot of lawyers who are into mediation, but in Germany and other places, a lot of psychologists are doing mediation, because mediation is not a lot about law. It's more about process. It's more about the skills of mediator. We are taught, okay, active listening. You need to understand body language of the parties. You need to make them disclose things which they're not willing to, and they will never do that till the time they're not they do not trust the whole process, and they do not trust that it is a confidential process. So I believe that confidentiality is something which is core of mediation, and signing a confidentiality agreement before starting of mediation, I think there's no harm in doing that.
Thank you for sharing your views on that, Mehak. A very important aspect, confidentiality. Another important aspect that is being highly praised when it comes to this bill is the online mediation, which is also said to be very convenient, very cost effective, and very accessible to everybody, including the common man. However, when it comes to confidentiality as being a very fundamental aspect under majority of the statutes, do you think confidentiality could be easily maintained on a completely virtual and online setup?
Sanjana, when we talk about, there's another buzzword, ODR. Everybody is very interested in what online dispute resolution is. But when we talk about courts have started online hearings. I was a part of arbitration at the inception of COVID. We did a lot of witness examination online. We tried finding ways to ensure that witness is alone in his room. Now the technology has become really better. There are 360 degrees cameras to ensure that witness is there, witness is alone in the room, and no recording is taking place. So I'm very sure technology is here to stay. I always prefer physical events over online events, but I do not mind online events. And similarly, Justice Chandrachud was also focusing upon online hearings going online, arbitrations are going online. So I think mediations can also happen online when, as I said before, breach of confidentiality. Even if, of course, confidentiality can be breached at any point of time, but anything that happens during mediation, until and unless a mediated settlement agreement is signed, it will never be admissible in court of law. So yes, there are flaws in technology. There are a lot of things that we need to train ourselves for. I am not very well versed with technology at this point of time, even after conducting so many sessions. Cyber attacks have increased multiple folds. So anything can happen, things happen. You discuss anything and it will start popping up on your Instagram. So mediation setting is no different. We need to adapt ourselves to technology. and we need to get better at it. But it is here to stay, and we should know how to take better use of it. And of course, one of the supporting organizations of this panel discussion is ADRAS. It's a very well built up, very tech-friendly ADR platform, which has been built up by Advocate Nitya Bansal. She's not here at this point of time. So yes, there are a lot of platforms coming up to ensure that it's conducted really well. So I'm very hopeful with technology as well.
Thank you for sharing your thoughts on that, Mehak. I absolutely second that to the thought that technology is here to stay and there is no moving away from that. So we have a very interesting question that I would pose to Mr. Ajilantam sir, that in congruence, which is asked by Mr. Ashish Kumar, in congruence of the present mediation bill with Singapore Convention for Mediation, how do we coexist with that?
Though the one thing I just want to share it that there is only one shortcomings in this mediation bill, that we never comply with the Singapore Convention for enforcement of international commercial settlements. This bill has completely omitted the Singapore Convention for enforcement. Probably that is not a big issue. But as far as international part is concerned, slowly India is emerging as a world leader after the G20 conference. So probably this Singapore Convention is also be included in the coming years. As Supreme Court advocates have said that it is only an infant stage, and slowly the Singapore Convention enforcement can be included in the mediation bill. That is one shortcomings of in this legislation in mediation bill, which when I go through this, that's what I just want to share it.
Yeah, and we are signatories to the Singapore Convention. We are yet
Yes,
to
yes.
ratify.
Yes, absolutely.
But as we have completely omitted the Singapore enforcement of international commercial disputes, totally the entire mediation bill has completely omitted the Singapore Convention. I don't know why it has happened. I don't know. I'm not aware of that. Not even a single point is mentioned in the mediation bill about the Singapore Convention of Enforcement.
No, there are some submissions of the government in the this standing committee meetings, but we are yet to find that out. So let it come out, and then we'll know what's the rationale of the government behind it of excluding the Singapore Convention.
Thank you very much to all the panelists for
Sanjana, your voice is breaking.
Voice is breaking.
Yes, she's having connection problems. Now you can turn off the
coexistence
video.
of the Singapore Convention with mediation bill. I'm so sorry. I apologize for that. Am I
That's all
audible
right.
now?
Now you're audible. Yeah.
Okay, I'm so sorry. I apologize for that. So
Another technology.
Yes.
Yeah, pros and cons.
So this is going to happen in ODRs as well.
Yes.
Yes, absolutely.
There is one more
Absolutely.
important point in. I just want to.
So Agilantam
Yes,
saying.
please.
Yeah, I just
Please,
want to
go
tell
ahead.
one more thing about this shortcoming of the mediation legislation is that Section 49. Section 49 is vague, and again the government is driving a coach with 6 horses, I feel. Section 49 of the mediation bill, I think it's a gap in Section 49. That could be whether central government or state government is involved. I think when the government changes, the situation may also changes.
Yeah, I was attending the Uncitral event. There was a similar question as to why government disputes are left outside the purview of this act. So yes, absolutely right, sir. There's another question. What are the highlights of this bill? Dikshita, I think we have been discussing the highlights of the bill since the panel began. Is there anything specific?
One thing is that the conditions for the mediator, we have to cross 4 stages. One thing is that we have to register with Mediation Council of India, and you should be an empaneled mediator attached to a court. And again, you should come to a state or national legal authority. So I think, see, now I'm a empaneled mediator in one of the court attached state, but I'm not a member in, I'm not been registered in Mediation Council of India, or I'm not registered with the legal state authority. So this process is little bit complicated for the mediators. At least this could be taken in a better way and can reduce the burden for the mediators.
I think, sir, setting up MCI will take quite some time, and having a uniform process for training of mediators, empanelment of mediators will take some time. We do have the act which was passed yesterday, but it's not that it's like a magic wand that tomorrow everything will start functioning as
it will become a magic wand if government becomes a party.
Absolutely.
Yeah, if there is some amendment in section 49, it will become a magical wand.
There is another question by Mr. Shiv, that there are many unreported instances where a mediator is found biased because of some temptation. How can Indian judicial system deal with such a grave issue?
I just want to share only one prorate for this confidentiality or bias. Caesar's wife is not beyond suspicion, as Shakespeare said. That is the one word. See, how can a mediator be biased, and how can a mediator will overrule the confidentiality? That basic things should be wiped out from the mind of both the parties. The trust is very important. Caesar's wife is beyond suspicion. So where comes the bias? If there is going to be a bias, then why there should be a mediation bill? Then why we are being a mediators? Of course, I do agree that because of certain, it depends upon every individual. On the whole, you cannot say that the mediation is a biased situation. I hope other panelists will also agree with me in this.
Very right, sir. Very right.
Thank you.
There is another question by yes, Shaurya, you were saying something.
Yeah, see, so first of all, we try to bring in the minds of the society, as well as the parties, as well as the business people, or as well as the general public, that the mediation is the best solution process for the long litigations in the court. As I said, it is a very, very supportive role to the advocates, as well as to the judges, as well as to the court. So one should encourage the mediation process in a better way, try to find out the shortcomings and rectify the shortcomings over the period of years, and to make mediation as the best solution in the legal system framework. That's what I just feel.
I believe that the results of this mediation and the upcoming Mediation Act would certainly entrust people with a lot of trust. And certainly the mediator and a judge and everyone should be like Caesar's wife, should be beyond any doubt, as Shakespeare said. But so the problem is the people are living in the era of Honey Singh and Tony Kakkar. So people do not know Shakespeare at all. So we have to go back to that era, sir. And we have to show that with our results.
Right.
That's
right.
what
I agree, sir. I fully agree, sir. I fully agree.
So Mr. Ashish Kumar says that there is no positive mechanism that exists as of now to include professional other than legal mediators into the mediators pool. What are your thoughts on the same?
I'm not a lawyer, or I'm not an advocate. I'm basically a professional. So I've been appointed as a mediator because of the credential which I have, credential which I have developed. That's what I can say that. So any good professional or any good lawyer or any good advocate can be a mediator.
So
and we have an example right now.
Yes, we have a live example.
Yes, absolutely. So Mr. V. Sundaresan has a question. He asked that is the mediator, should the mediator have educational qualification as BL or LLB? I think in the
That has
previous
already
question,
been
sir already
answered. Yeah.
answered that, and we have a live example in front of us. So that's all with the questions. If anyone wants to ask any more questions, you can unmute yourself and ask, or dropping your queries in the chat box. Okay, we have a question from Mr. P. Dhananjay. He asks that does mediation have any scope in resolving insolvency disputes?
No, insolvency is a separate, that IBP is there, and NCLT is there. Insolvency professional is totally different from this. But anyhow, in future, mediation can also take the insolvency part it and do a better course of time, I think.
Sir, I believe that mediation is a preventive discourse for any wound, and insolvency is a process of healing itself. I think it's not preventive. So that's the difference.
And Schedule 2 of the bill specifies the statutes where this will not be applicable. So I think that doesn't cover insolvency per se. So mediation can be applied in a lot of various kinds of disputes.
Yes.
So on the same grounds, I have a question on the subject matter now that we've discussed about the same. The grounds to challenge a mediated settlement agreement is included in the bill as a fraud, corruption, impersonation, wherein the subject matter of the dispute is not subject to mediation. Do you all think that this is a very restricted and exhaustive list and that it should be enlarged a bit?
No, it's very loosely drafted in comparison to any other civil legislations. I mean, there is no coercion into that. If a party is coerced into signing the mediated settlement agreement, then this particular portion is not included here. If a mediated settlement agreement is signed by a mentally unsound person, a lunatic person, that is not included in the particular act. And any mediated settlement agreement, if it is signed for the purpose of any illegal activity or for the suppression of any evidence or for any corrupt activity, it is not included in the agreement. So I believe that it is very loosely drafted in that sense. So I believe that the view and the intention of the legislature is quite liberal in this particular sense. They want the litigation, the litigation to be mitigated and pre-litigation to be increased. So they are very much liberal in the drafting of this particular act as far as I am concerned. And as I have read, this is my point of view.
So that I think that is to retain the whole essence of mediation as a process of dispute resolution. Sanjana again froze, I think. There's one more question. How does a mediation end? What sort of document as a closure one? So if parties come to a solution, there is a mediated settlement agreement. If it is a pre-litigation mediation, one party does not appear, there's a non-starter report. That's all right.
So Mr. V. Sundareshan has a very general question.
Yeah, Sanjana, I was answering that.
Thank you very much, Mehak. I hope I'm audible now.
Yeah,
I'm so sorry. I think I am someone who's still struggling with technology and all these glitches. I'm sure in some
No,
time
I
and no
think
No,
time
you
will
are
be
just
okay
highlighting
with
the
that.
challenges we are going
challenges
to face in
ODR
now.
is going to face, absolutely.
Yes, I am a light example of that. Thank you very much to all the panelists for sharing their insights with us. A last parting remark, as I would request all the panelists, now that we've understood the challenges and the objectives of this bill, do you think this bill actually has the potential to pave a path towards effective dispute resolution? As a parting remark, I would request all the panelists to share their last thoughts.
Certainly, I fully support this legislation, a long pending legislation, and certainly it will have a very good impact in the society in the coming years. As If Lord Krishna's mediation could have been succeeded, there could not be no Mahabharata war. So take into that Mahabharata concern, and we can adapt the mediation process in a better way, that there should be no legal war between the two parties, and everybody should have a harmony and peace of life. That's what I just want to say about this mediation bill, as an individual is concerned.
Thank you
As far
for
as
that,
myself
sir.
is concerned.
Thank you for that, sir. Mehak and Shaurya, if you want to build on the same.
Thank you, Sanjana. I'll speak first. The mediation, as Agilandan sir very rightly said, it's there since time immemorial, and it's a very vital part of our civilization since Vedic era, be it Mahabharata or be it Ramayana as well. Mediation was present before every legendary battle that involved a lot of blood and a hell lot of cost. If you talk about this particular mediation act, I believe it still has to go through and walk through on Agni Pariksha, which is there in the courts. The provisions of this bill are yet to be discussed, argued, and debated in the courts of law. And as I stated in the sessions earlier, it still requires certain amendments and has to make the ecosystem of pre-litigation environment more secure and prosperous. This is all I can say at this pre-litigation, pre-enactment stage of this much awaited pre-litigation law. I hope you would remember to be a part of this session and have a smile at your face whenever you see this law doing something good to the law, to the society as a whole, or maybe changing the entire ecosystem of the traditional litigation. And again, I'll just repeat what Krishna said when he went to the Kauravas with Pandav during that pre-litigation of Mahabharat, that वर्षों तक वन में घूम घूम बाधा विघ्नों को चूम चूम सह धूप घाम पानी पत्थर पांडव आए कुछ और निखर सौभाग्य न सब दिन सोता है देखें आगे क्या होता है. So I wish all of us a very best with this particular bill and with this particular act, and thank you very much for hearing me out with all your patient ears. Thank you. Thank you, Sanjana. Thank you.
Thank you, Shaurya. It was a pleasure to listen to you too. Mehak?
I think everything has been covered. Just to close it up, as I said, I'm a very pro mediation person. As mediation being a means of dispute resolution, I'm yet to see how effective the act is going to be. But yes, there is a need to accept the act and accept mediation here, because I recall one of the legal heads of a boutique company calling me and asking me a lot of questions about what pre-litigation mediation is, how it is conducted, and why we have filed it. So I think if we ourselves are not aware, we ourselves do not take it more than a process which is just to bypass the court proceedings or just to buy more time in court, then it is not going to be successful. Of course, we need to open ourselves to the process and to actually attempt mediation for resolving our disputes. Thank you.
Thank you very much, Mehak, for sharing your parting remarks on the same. I'd like to thank all of the panelists, our esteemed panelists, for joining us today. It was my absolute honor to host you all. And I'm sure your expertise and knowledge helped us
Sanjana,
understand
there was a question, I
now.
think we can take it up. If mediation is being more successful, will it not affect professionalism of judiciary? Ashish sir has said dispute market is so large that a big pie of mediation can easily be accommodated without eating into others' share. Anybody would like to comment upon it?
No, so I totally agree your point that since the judicial system is an ocean and mediation is only a small part, it has to go a long way. And no, it will never cut into the pie of the judicial system. And everybody will have their own share, and everybody will do their own justice and work according to their profession. That's what I just want to say. That
I think judiciary is going to face more threats by the upcoming artificial intelligence being acting as the lawyers, or maybe they'll be acting as judges someday.
Absolutely.
There are constant threats. But we have to be prepared, we have to be evolved. That's all.
Thank you, sir. Thank you, Shaurya. I'm sure all the
Thank you so much.
participants enjoyed this session as much as I did by moderating the same. Thank you to all the panelists for joining. Thank you to all the participants for
Thank you very much.
joining and patiently
Thank you.
listening. I wish everyone a very good day ahead.
Thank you very much. Thank you all.
Thank you.
Thanks to you,
everyone.
Sanjana, as well. You were a
Thank you.
fantastic
Thank you
moderator.
very much. Thank you all.
Thank
Thank you,
you.
Sanjana.
Thank
Thank you,
you,
sir.
Mahesh.
Thank you very much.
Thank
Thank
you
you.
again.
Thank you.
Thank you, sir.
everyone.
Thank you.
Good night.
Sir, thank you. Thank you.